Hi, everybody.
Good morning. My name is Glenn Fani.
Good morning, Frank. Good morning, people. I'm Debbie Faulkner.
And so it's a little different than being at the library, but as we know, it's different times now. So we're trying this out as a different way of communicating. We've been doing these seminars for a while now, and I think what's so interesting is the questions and comments and directions that this has taken us. And as we know, we're here talking to you about a bunch of different things, but trying to focus on what's most important at this point. We have a lot of people that I think are kind of looking at this whole pandemic, right? And kind of looking at that and saying, hey, I should be thinking about some things that I possibly haven't thought about, or it kind of makes you kind of stare at yourself and think about some things that most people don't like to speak about. And so we're going to get started there. We are sponsored this time by Faulkner Law, Burke Faulkner Law, and also the Gulf Coast Estate Planning Council. Just a little commercial about the Gulf Coast Estate Planning Council. It is a nonprofit that Debbie and my partner Brandon started several years ago. And basically it looks at a really, really scary statistic that 70% of people here in the United States do not have their legal documents. And as you can imagine, not planning, you've already kind of have a plan. Unfortunately, it's the state of Florida's plan and the government. And so that's probably not a good plan. And so that's what the council is about, preaching how important it is to have your estate. And so what we feel is doing these kind of seminars can only help to communicate people. They want to be educated. And so that's why we do this. So Gulf Coast State Council and Burke Faulkner Law. And we're going to let Debbie get started talking about a couple of things that I think are mostly on top of everybody's mind right now. So we'll go ahead and get started with Debbie talking a little bit about health directives and things like that.
That's right. Thanks, Glenn.
Okay.
I'm Debbie Faulkner with Burke Faulkner Law. I'm the managing partner of Burke Faulkner Law, and we are happy to be presenting via webinar today. Okay, so one of the things that's going around about coronavirus is that a lot of people are going into the hospital to get tested, and we're obviously all worried about both our mortality and our infection rate or our sickness rate. There's something that's important to know about an estate plan. So the difference between having a will and having an estate plan is that with the proper estate plan, you have advanced directives or healthcare and financial directives that help you during your lifetime. I'm going to go over those in turn before I get to talking about wills and things of that nature. Most importantly, everybody should have a designation of healthcare surrogate. What that document does is one of the 5 advanced directives is it names somebody that can make a healthcare choice on your behalf if you're unable to speak by yourself. So for example, if I went into surgery and I was scheduled to have surgery and be put under anesthesia, if a doctor finds something in surgery they need to do further operation for, I'm not able to speak on my own behalf. I name somebody like Glenn, or in my case, my mom, who can tell the doctor yes or no on my behalf or make an important medical decision. Unlike a financial power of attorney, in Florida, your healthcare power of attorney does not have the power to speak on your behalf unless you're unable to speak for yourself. So this comes into play a lot as we age and people are put on morphine and things of that nature. But it's also when we go into surgery or somebody's, on a ventilator, anything like that.
One question that we've got a lot associated with this, Debbie, is that a lot of people say, well, I signed something when I went to the hospital.
Right.
And that is true. Most of those documents, you want to talk a little bit about that from the perspective of it's really what's the hospital is looking to get out of that document versus what you are, correct? So that's a question that we've had a lot in the seminars about this document that the hospital or the facility is going to ask you to sign. It does call itself a directive.
A directive. So a lot of times when we go into a hospital or a medical facility, you sign a healthcare surrogate possibly, and also a living will. So that's the second directive we're going to talk about, is called a living will. So this directive is different than your last will. A living will is a document that says what you'd like to happen to yourself if you are either in a persistent vegetative state or you have a terminal condition like cancer that happens to you, or you have an end-stage condition like kidney failure and internal failure, and 2 doctors have said you're not likely to ever recover from this illness, you're essentially hospice eligible. Your living will says that you want to either be treated further, or you would like to cease all treatments if you're in that condition and pass of natural causes. Oftentimes, if we go into surgery or we go to a hospital, they ask us to sign both of those directives. And your third directive, which is your HIPAA form, the HIPAA is a healthcare act that's a federal act that's basically, we all know kind of what it is. It's your healthcare information is protected from all people unless you designate specific individuals to be able to receive that information. Obviously, if you're designating someone as your healthcare surrogate or somebody to carry out your living will directive, those people need to have access to healthcare protected information. So we sign a third directive that gives that permission to the healthcare provider to be able to share those important healthcare information with you.
Okay, let's stop there for a second. I think we have the ability, if anybody has any questions, they can go ahead and type those in.
Right.
And send those to us. So we want to try to make sure that we're answering questions. Normally in our face-to-face meetings, we do get a lot of questions during the sessions. And honestly, mostly it works out very well because somebody has that question. Sometimes they're afraid to ask. So the questions and answers are something we're going to really try to see if we can get from you in this different way of doing it. But main reason for that is we want to make sure that your questions are specifically answered. And we have a lot of hand raising in our meetings that we have. And so I want to make sure that we get that covered. Debbie, the only other thing I think I want to cover around that area, it seems to be what I'm seeing with the HIPAA, those were all changes that were made in 2011, correct? Or
with your financial
with
power
a financial
of attorney.
current, right? So there, just so you know, a lot of people, we also say, well, I have documents. And one thing we are seeing, a lot of these documents, if they're done prior 2011,
That's right. Mm-hmm.
you probably think that they need to be updated.
There are various forms that were changed by Florida law in 2011. So those, a lot of older estate plans have documents that predated the statutory overhaul. So the main statute, one of the main statutes that got overhauled in 2011 was the financial power of attorney. So a lot of powers of attorney that preceded that date are no longer really effectual. I've heard of a lot of clients having their documents rejected outright by banks and other financial institutions. So that's something to definitely take a look at.
And prior to that, we didn't have any language in there for HIPAA, did we?
Right, right.
So now we have that HIPAA privacy issue that is there. So the other thing I think that's important to understand with this prior to 2011 documents, I know personally when I did my health directive, I thought it was really interesting how you had the ability to pick and choose the boxes of how much intervention. Kind of look at the Terry Schiavo. I can't say that. That's right. The Schiavo situation where you can actually maybe talk a little bit now how the new document, if they understand, they can actually pick and choose what types of medical intervention can happen. So talk a little bit about that.
So on the living will document, I often refer to it as the Terry Schiavo document because it is the document that says what we'd like to happen to ourselves. It's kind of a gift to your family that says, hey, if I'm in these conditions, I would like these interventions or I would like to be left of natural causes. A lot of times on the hospital form, it's just a yes or no. I want to either be kept alive or I don't. On our form and on a lot of attorneys' forms, we have different interventions listed out, and you can pick and choose while you are of sound mind before you're ever in that condition, whether you want to have a ventilator in that situation, whether you want to have artificial nutrition, whether you want to have artificial hydration, whether you would like to have chemotherapy, whether you'd like to be put in an ICU where they have a lot more heightened amount of medical intervention going on at that time. So on our living will, it's not just a yes or no answer. You have the opportunity to think about it while you are not in that state of mind, while you're not in that condition. You're able to say, okay, yes, I want to have nutrition and I want to have hydration, but I do not want any new cancer treated if I'm already going to pass away of natural causes. So that's the type of customization that you're able to have when you think about it ahead of time. Looks like we have a question.
Yes, Debbie, we have a question. It says, if the will and trust is done we still need a lawyer to execute when someone passes away.
Wow,
Wow,
that's a great question.
question.
So I'm going to be a little, I have a tendency once in a while to not sound like a conspiracy theorist, but there's certain interesting things in the state of Florida. Yes, if you pass away in the state of Florida with just a will, I think it's an interesting conversation, and Debbie will explain to you exactly what the answer is. And there's a threshold. It's a pretty low threshold, but it's a threshold. So go ahead.
Right. So the question is, if a will or trust is done and somebody passes away, do you still need a lawyer? Well, guess what, guys? Most legislators in the state of Florida are, you got it, lawyers. So what the legislature of Florida wrote into law is that if you pass away owning more than $75,000 of assets in the whole world, and those assets are passing to the next generation, if it passes through a will, meaning that you require probate, then you will require a lawyer. So that means if your total estate is worth $75,000 or more, including your house, all of your assets, your family will have to hire a lawyer to go through the probate process. So one of the things about wills that we often hear is, well, if I have a will, I don't need probate court, right? Wrong. So all wills, if property goes from you after you pass away to the next generation through a will, then you will have to go through court. The court supervises that process of moving property from one generation to the next. So sometimes I get the question or the comment, well, one of my parents died and they didn't need any court process. That's because there are certain ways that you can avoid probate altogether. One of the most malleable, most easy way is to have a trust that's fully funded with all of your assets. I'm going to go over that in a few minutes. But the other way is to have everything jointly held with somebody else in some way, shape, or form. So if you have all 100% joint assets and you don't own anything by yourself, then whoever your joint owner is going to be able to avoid probate. But other than that, if you're passing money to kids or passing money to charities or passing money to somebody you don't have all joint accounts with, they're going to have to go through probate if you have a will.
And I love Debbie has renamed probate to wills court.
That's right.
So let's talk just a little bit more about wills court. So if you have a will, you're going there and you're going to get probate, have to go through the probate process. And I think there's some shocking things to look at probate as far as time. And for me, as far as cost, maybe you want to talk a little bit about the process of going through wills court.
Sure. From
a perspective of time.
Sure,
and also
absolutely.
From a perspective of cost, because again, the lawyers who wrote the law actually wrote a price in there and a bunch of ways in which they can charge more than the base price.
That's right.
Crazy
So,
idea, right?
If you die and you pass to your heirs with a will or through a will, the attorney is able to charge 3% of your entire estate as their legal fee. That's just the legal fee for a basic probate if you own no houses and no real estate. If you own real estate and you have various other assets, there's 20 other ways that are written into the law that attorneys can charge more than the 3% statutory fee. Your executor is also allowed to charge a 3% fee. They're able to charge more if there's a lot more work involved, but that's the base fee that the law considers presumptively reasonable no matter what the situation. So for the lawyers that are involved, they're allowed to charge 3% automatic, plus there's about 20 other ways that you can charge more money in the statute. Now, if your lawyer writes your will, they can also write into your will that they're able to charge more in various other instances. I was reading somebody else's trust and will the other day, and the lawyer wrote 8 other additional ways that he could charge the heirs money in addition to what the law provides. So he basically made himself able to charge 8 different ways from Sunday.
Right. So what's interesting about this concept of wills court, I refuse to call it probate because a lot of people don't understand what probate is. But if I have a will and I get to go to wills court, right, is an interesting thought in the process that we've seen a lot of people in attorneys saying they'll do a free will or they'll do a will at a very low cost. Well, let's think about that. If they know that they're going to get 3% on the back end when they have to probate it, do the math on just a simple $200,000 estate times 3%, that's a pretty big number.
$6,000.
A lot more than what they would have charged for a will, or they could have charged for the will up front. So we see also a situation, and I want to talk about this, Deb, important. I've had a lot of questions in these seminars and these talks, and a lot of people really frustrated in the fact that they can't find their original document. Okay.
Right.
So a lot of the attorneys will keep, attorneys that do the free or low priced will, they'll keep the original signed document, which is the only one that can be presented to court. There are a few other rules, but pretty much that's their way of having the client come back to them and pretty much assure that they're going to be doing the probate part of it. So people will say, yeah, I got a copy of the will. And I go, where's the original? I don't know. Talk a little bit about that.
Right. So in the state of Florida, if you pass away, you need to have the original will. So the original will is often held by lawyers, and it's not necessarily for a nefarious reason, but a lot of times clients move or relocate, but the attorney generally keeps the original will. The little known fact is that you do not have to return to that attorney to go through the probate process, no matter what time or what day. If you want your original will back from your attorney that drafted it, you're welcome to request that document, and it has to be released to you. So really, but a lot of times people don't know that. They return back to that lawyer, whether they liked them or they didn't like them, because that's all that they know how to do. But the attorney's job, if somebody dies and they have a will in their possession, if you call that lawyer and say, hey, I want a copy of the will, they'll give you a copy if you're legally entitled to it. But by law, the attorney has to file that will with the court within 14 days or so of learning of the person's death. So you won't really get the original back if somebody has died, but it will be filed in the appropriate court so that the probate process can continue with whatever lawyer the family chooses. So I want to go back a little bit to the advanced directives to just wrap up that part of our seminar.
And again, this is an important part, because what we're seeing now, again, let's talk about the virus and what's going on there. These are things that I think a couple of things that we have to recognize. The fact that, number one, a lot of husbands and wives will make each other their health directive.
That's right.
And the problem there is if both of you are there, so having somebody else past a spouse or a significant other, doesn't really matter. You probably want to rethink that and have somebody else. And normally your documents issue or list how many different people?
At least 3 different people. So in Florida, your spouse is not automatically entitled to be your healthcare surrogate. So your healthcare designee, the person that's entitled to receive healthcare information. You have to have a legal document. Sometimes they're provided by the hospital if you go in for surgery or something, but you can prepare them in ahead of time and have copies for your physicians and for any facility you may enter. You have to name somebody specific that's able to receive your healthcare information and be able to make choices on your behalf. And this is not automatically your spouse. Some people say, well, why not? There are a lot of different people who stay married who are not on good terms with one another. So if you're not in that situation, you may not believe that to be true, but trust me, it is definitely the case. So you have to have a healthcare directive that indicates who you'd want to help you out in that situation.
Also talk a little bit, and I know you've got some other points. I want to make sure we around the same theme, the idea of a preneed guardian, because that kind of is the same situation. I've had many, been doing this about 25 years now, and I can think of numerous cases where we've had a situation with a guardian needing to be appointed.
And that's been in the newspaper a lot lately too, Glenn.
Right.
So sometimes we prepare a document called a pre-need guardian designation. And a lot of times people are like, well, if I have my healthcare directive and I have my power of attorney, why do I need anything else? And here's the situation. In Florida, as in many other states, you may become in a situation where those documents are insufficient to take care of you. This typically happens if we contract dementia or Alzheimer's, where we're no longer able to protect ourselves from ourselves. So for example, I had a client who called me up and said, my brother lives down there in Florida by himself. He's 83 years old. And when I talked to him, the gentleman believed that he was still active duty military. So what do you think happened? there was women coming out of the woodwork claiming to be his girlfriend. He didn't know one from the other. He wrote checks to all of them. So he was depleting his estate, endangering his own ability to continue to provide for himself, but he was none the wiser because his short-term memory was gone. So a preneed guardian designation you make when you're still cognizant, aware, and you're not in that situation. This might be something important for our parents, let's say, and you say, if I'm ever in this condition, court, please name this individual and not anybody else. It also wards off any family disagreements, things that happen when somebody is in that condition. Sometimes people fight over who's going to take care of mom or dad, especially when families don't get along. So you are able to name who you would like to take care of you if that ever was your situation. And we certainly hope that none of our clients ever need that form, but in the alternative, the court names somebody that the court chooses or names somebody off of a list if there are nobody that steps up to the plate. That's what's called a court-appointed guardian. And that's what's been in the newspaper a lot recently, of a lot of court-appointed guardians taking advantage of the people that are under legal disability.
And also, just to reiterate, and sometimes I just want to make sure we understand that a spouse is not automatically made that guardian without a document. So what we see is in the worst time when somebody is very ill or there's a situation, and now we have to go to the court system and we have to get approval, money again, and time, correct?
Right. It's a guardianship proceeding is thousands of dollars and it takes time. There's 3 certifying physicians that have to evaluate the person. If the guardianship is not contested, the person is not arguing that they need to have their rights, then the form can be filed and the whole proceeding can be a lot simpler and easier. So the final advanced directive that I wanted to mention is your power of attorney. Most of us are familiar with the concept of power of attorney. I'm just going to mention 2 things about it. The financial power of attorney is the keys to your financial kingdom. So what that means is that whoever you name is able to stand in your shoes and do whatever you're allowed to do with your finances. That means they can go open a bank account for you. They can sell your house for you, can file your taxes for you, get a refund for you, open your mail, open your email. Anything that may have value to you, your power of attorney is able to do on your behalf. Now, in Florida, in the statutory overhaul we mentioned earlier, Florida decided that you cannot make your power of attorney effective in the future. What that means is you cannot say, I want person X to be my power of attorney if I'm disabled. No longer in Florida. You cannot do that. Whoever you name is that person as soon as you walk out the door. So as soon as you sign that document, it's live. That person can go clean out your bank account tomorrow. So we do not recommend having anybody named on this document that you do not trust 110%, that they will not clean you out, they will not drain your finances, and this person will take care of you and look out for your best interest.
So let's go a little further here. In the state of Florida, they refer to it as a durable power of attorney. And
Right.
the durable part means that as soon as it's implemented, it's durable, it's going to work. A lot of times, if you have some concerns, which again, the person that you make your power of attorney, you need to make sure that you have ultimate trust in them. But a lot of times you'll look at holding that document for them, right? Or
Right.
putting it someplace so that that's not accessible, correct?
Right. So the way that we get around the statute not allowing it to take place in the future is that you can put it in a safe place. You can have your attorney hold it in abeyance and basically have a set of instructions that say only release this document if this is presented to you, things of that nature. So we just got a question. It says, with coronavirus, I'm concerned. If something happens to me, how will my family start the process with the courts being closed? That's a great question.
Is
So unbeknownst to most people, the courts are actually not closed. Courts are operating on a skeleton staff and not having in-person hearings, but as an attorney, we are still able to file cases and have hearings with the court, with the judge. They're just primarily being handled telephonically. I can't speak for all the courts in the whole country, but at least locally here, our courts are operating and they're continuing to take new cases.
correct. And I happen to know, in fact, I have several clients that work in the court system in Tampa, and I know for a fact a lot of them, just like everybody else, are working remotely. And so they're either working at home or they're in different facilities spread out around the town. And so, yes, everything's still moving along, and it's just being done. I don't know if people know, the stock exchange floor was closed on Monday. We had 2 members of the stock exchange that were tested positively, but the system can run, and everything has been running since Monday, all remotely. So the system is pretty smart in the fact that we can handle things like this. The other thing I want to go into, and it's extremely important now, again, some of those things that we don't think about a couple of years ago, digital assets. Talk a little bit about digital assets and the law associated with where they have to be in a document.
Right. So a few years ago, Florida enacted a Digital Assets Act, which means that some of the older documents that we're talking about, if your plan is a little bit older, don't reference any of your digital assets. But people are more and more putting important things like photographs and memories they're keeping on Facebook or on some digital photography apps and things of that nature. You can have a lot like websites that have a high value, things of that nature. In Florida, you have to specifically allow your power of attorney or your executor of your will, which is called a personal representative in Florida, or your trustee. It has to be specifically authorized to access those assets. And at the federal level, the American Bar Association and the estate planning attorneys like myself, we have had a lot of meetings at the federal level, the ABA level, arguing over whether or not accounts need to be shut down if somebody dies, or whether there is somebody that's authorized to carry on those accounts. At least with Google, they have the ability to designate a successor that's allowed to access your account in the event that you die. Sometimes people already have the passwords and are already able to access these accounts, and that's not very highly monitored in any way. But if you are somebody who's ultra private and does not give anybody access to your accounts, there are procedures in place that you can specifically designate for accounts on Google. But there also, if you give a blanket access to your executor, your personal representative, your trustee, your power of attorney in your document, they shall be allowed to access those assets in the event that they need to. So we obviously include the digital assets in all of our documents, the will, the trust, and also power of attorney, so that there's never any question that your digital assets are also protected and able to be handled by your family.
And I think one other thing, let's make a commercial for an upcoming webinar now, I guess, since it's a
All
situation.
webinar now.
We have in the Gulf Coast Estate Planning Council, there's something called the Family Love Letter. And I kind of explain the Family Love Letter this way. Let's unfortunately say you passed away today, and you were thinking back and said, wow, what's all the things I would like to have my loved ones know, my business partner know, my kids, my grandkids? What would I like them to know if I could go back and write a document, or somehow make sure that these things that I've known were important all my life, I just never documented anywhere. And so we call it, and it's a very interesting program I've been working around with since 2006, called the Family Love Letter. And we actually are putting together a webinar like this to help you work through the Family Love Letter. It's one of the major initiatives of the Gulf Coast Estate Planning Council. And so if you are interested in the Family Love Letter, it's an awesome way, and it basically is a document, can either be digital or it can be paper, and you fill it out, and it basically is a roadmap to your life. And it says, hey, what's important to me? What are the things that are most important to me? What about my ethical will? What do I want my grandkids and kids to know? Talks about heritage, talks about personal documents that are important, pictures. It is an interesting thing, because some of the areas that get most attention when we do the conversation, or the workshops, I call them, is like, how many people have pets? All right, so we have beloved pet, and mine is a new addition to our family. His name is Oliver. So I love Oliver. Oliver's awesome. And so Oliver, if something happens to me, who gets Oliver? And oh, by the way, am I going to leave some money for that person to take care of Oliver? He's only 2 years old. So this covers a lot of those things. And what it does is think about this. And if anybody's dealing with, I'm 57. I'm 58, right? Last week, sorry, 58. And I always say that we're the sandwich generation. We're sandwiched between our kids over here and our parents over here. And so when you look at that, think about, and I have it happen all the time, had a real interesting conversation with somebody from our last seminar a couple weeks ago about someone passing away unexpectedly, and the spouse has no idea where things are, how many bank accounts there are, where money is, because old school. The husband took care of everything, and
Happens
the
all the
wife
time.
did not know much of anything. She just knew there was money in the account and she could go to the grocery store and things were taken care of. And it is like a major mystery to try to figure out where to go from here. So the document would actually allow you to list all your passwords to your computer, all your assets, how many bank accounts do you have? If you're a VA, what are the, what's all the information? Because there's certain numbers you need for the VA administration. So I want to finish my talk about the Family Love Letter, saying that it's something I think that'd be very beneficial. If you want to join us at one of those sessions, we're probably going to break it up into a couple of different sessions. Please email us and let us know, and just put Family Love Letter, and we'll make sure to keep you posted on the upcoming events that we'll be doing for the Family Love Letter. So sorry for the commercial, but I think it kind of ties things together when we look at this situation. We look at really what we're trying to accomplish is getting our life in order, right?
In a nutshell, the Family Love Letter goes with your estate planning documents and kind of acts as like an inventory of sorts. It also helps you to leave like a last letter for your family of what you want them to know. So whether that's like something moral, your ethical values, whether it's life advice, things like that, and it's all packaged together in one unique package called the Family Love Letter. So it's a great thing to talk about. We got a question during your talk about providing for pets. So there is
we always get a question about pets,
and that's a great thing, because last week in my life, my baby is a fur baby. I have a dog named Nina, and she is my only child. And last week she decided somehow, I don't know how, because I didn't eat corn, but she ate a corn cob, a piece of a corn cob that got lodged in her intestines, and she had to have emergency surgery. So I asked myself, the surgery was quite expensive, over $5,000 for the day of surgery and her recovery. And I asked myself, what would happen to Nina if I wasn't the person who was in charge of making that decision? Certainly a lot of people say about other people's dogs,
right,
well, I would never spend that much money. I would never want to drain the account like that to pay for my pet to have a major surgery. But folks, my pet is my life. So it was a no-brainer for me. I spent the $5,500 last week to get my dog back to normal, and she's alive and well and doing well. But this is very important for a lot of people, not just myself, about how to plan for pets. So the question is, I want to make sure my dog is looked after after I pass away, for however long they're left. Is that hard? And can I put my pet in my will? So that's going to transition very well to talking about wills and trusts.
Yes.
Because you cannot provide on an ongoing basis for your pet or your children or anyone through a will. So I want to talk about the basics between wills and trust, and I'm going to get into that now. But I want to say at the beginning that for pets, for children, for beneficiaries, a will, while it provides financially for them, does not allow you to provide for people over the course of time. So the only way that I could protect my baby Nina and make sure that she was able to get surgery if she needed it is to provide for her through a trust. So here I want to talk about, I've written some different things on this board to go over with you. At their core, a will we all are generally familiar with. A will and a trust, though, at their core are both a legal document that is a set of instructions about what you want to happen to your property in the event that you pass away. A trust is also a set of instructions about what you want to happen to your property, but you're able to provide what you want to happen to your property if you become disabled or if you die. So that's one difference between a will and a trust, is basically, let's say I contracted, I just got old, let's say, and I wasn't able to handle my finances anymore. This happened to my grandparents a few years back. They just couldn't handle that anymore. They just wanted to relax. They wanted somebody else to handle their affairs. Whoever you name in your trust as a backup trust person, you yourself are in charge of all your money, but then you name somebody as a backup called a successor trustee. That person could step in on my behalf if I'm disabled or I just decide I don't want to handle my finances, and they could take care of my directions and take care of any of my financial decisions for me for the money that's inside my trust. So basically you can write things in there like, if I become disabled, I want to be kept at home, no matter if it drains all of my money out of my account, or leaves $0 for my children. I want my care to be at home and not in a nursing facility. That's something I see very often as disability planning within a trust. But the other major difference between these documents, I want you to think of them as a set of instructions about what you want to happen to your property. But the second part of a trust is that it operates kind of like a bank account. What I mean is that you have the base legal document, which is your set of instructions about what you want to happen to your property, but you also have to fund a trust. So that's kind of like a bank account. I want you to think about, if I go down to a bank and I open an account, I sign a legal document, and that legal document takes effect. It says what the bank does for me, what I do for the bank, what our responsibilities are, and things of that nature. But what happens if I never put any money in that bank account? That contract is still in effect. It's still legal. It's still a legal document. But there's nothing for that legal document to govern. And that's what a trust is. So a trust has to be funded with money, with property, with things like that. So that's something that gets a little bit confusing. So what I want you to think about it, though, that if you put money into the trust, then that set of instructions applies to that money. So what that means in its essence is, if I sign a legal document with my lawyer, I have a trust now. If I never put money in an account called a trust account, then that contract, that trust, doesn't really do anything.
So like the bank account, right? I
Right.
can open a bank account at a bank. I can sign it. By the way, there's a bunch of lettering and a bunch of words on the back of the document that no one looks at. It's the rules of the road of that account at the bank.
Right.
It says that if you sue them, it's going to go to arbitration. No one reads all of it, but there are contractual things in that opening of an account at a bank. But again, like you always say, if here's the question: is it really? If I don't put any money in, is it still a contract, right? Is it still a viable contract? And of course it is, right?
It is, but it doesn't do anything. So a lot of times I see people that have a trust and a will, and they come in and I say, "What's in your trust?" And they look at me like I have a couple of different heads. The reality is, if your lawyer gives you a will and gives you a trust, but never tells you to put anything in your trust, then you really only have a will that's going to do anything. So a trust is a little different than a will, in that a trust doesn't stand on its own because of this fact. So if you have a trust document, the lawyer's also going to give you a will. What the will says is, if I die with nothing in this circle, then everything that I own, I want in that circle when I die. So that's called a pour over will. What it's designed to do in a perfect world is to allow you to, is like a backup plan. Like if you forget to put something in the trust account, then it does that for you, so that your one set of instructions apply to all of your assets.
Let's stop there for 1 second. Do we have any questions or anything like that?
Not right now.
Okay, so let me just add one other thing at this point, because it's really difficult doing it via this way. I can
Very
usually
hard.
see people's eyeballs, and I
Right.
can see whether they're going yes or no. So one of the things I think is important is we get really confused with this trust situation. The will seems to be pretty straightforward, but when we get into the trust world, it gets confusing. So what we have to understand is, we basically develop a trust. It's revocable. What does that mean? That means if I want to change it, Glenn can change it anytime in his lifetime, as long as he's competent and he's alive. So let's go back to the specific question about your pet. So let's say something does happen to Glenn and he's in the hospital. Well, it automatically says, again, the trust will handle things while I'm alive,
Right.
and after I pass, opposed to the will, which only comes into place when I pass away. The trust says, hey, Debbie is my best friend in the whole world, and I want Debbie to take care of Oliver, and there's money put aside for Oliver's care, and I want him to go to this vet, and I want him to spend any money that's needed, and I can measure an amount. I can say any money up to whatever, but I can put specific things that can get into effect if I'm disabled. So I get in a car accident, or I have this dementia. It's all handled. Oliver's taken care of on my
those
trust.
directions.
And there's no arguments, right? Because if someone else comes and says, no, I'm supposed to take care of Oliver, Glenn said that yesterday. Well, sorry, that's not how it goes. So I want to be specific on that question for you, as far as what can I put it for the pet. The trust really makes a great way of getting all of the confusion and the misunderstandings, let's say, that could pop up even with a pet.
So I have a great question that came in just now. It says, I live on the phone. I live in Florida during the winter and New England during the summer. I have property and bank accounts in both places. Do I need 2 wills or 2 lawyers, or how does that work? That's a great question.
That is, we have a lot of people who
That's
have
a very
multiple.
common question in Florida since we have so many snowbirds.
That's right.
So you only have 1 will. So you have 1 will, and that should be made in the place where you are domiciled, the place that you consider your home. You can have 2 houses, but the place that you live in more than often than not is the place where you should have your will. If you do have property in multiple states, you automatically should have a trust more so than having just a will. And here's why. If you die owning real estate or bank accounts or things in more than 1 state, then your 1 will has to be probated, has to go through wills court in both different states. Bank accounts, not so much. I should say it's really real estate. If you own real estate in Massachusetts and you own real estate here in Florida, your will has to go through 2 different lawyers, 1 probate attorney in Florida, 1 probate attorney in Massachusetts, and go through the whole court process 2 times in order to pass the property from 1 generation to the next. Because Florida law they cannot have any jurisdiction, is what it's called. They don't have any right to say anything about Massachusetts property. So that's one of the reasons that you want to consider having a trust. There are other reasons. I'm going to turn this board around.
And I'll talk a little bit about some of the reasons that I think need to be thought about with a trust. I do not think it's a magic bullet, and I think
Here we go.
Well, I think if we turn it more this way, we
There
get
we
rid of
go.
that reflection.
All
There
right.
we go. We're actually working this out pretty good there.
So, I've written the wills and trusts on the board so that we can go over some of the differences. We've kind of talked and touched on a couple of them, but it's very important that we cover a few others just so that the other concept, that I wrote on the other side of the board makes a little bit more sense. Wills, as I mentioned earlier, go through probate, which is also what we like to call wills court. So if you die owning property and it goes to the next generation, it goes through wills court, and that involves the attorney fees and the costs that we mentioned earlier. The other thing that Glenn is referring to with the pets, and that I referred to a little bit, is that if you pass money through a will, what that says is money is paid right away. So and that means after the court process is over. So let's say Glenn dies. We're killing you off, Glenn.
Thank you.
Glenn dies and leaves money to his 2 twin boys. And he says, I want my estate divided in half between my twins. And that's that. As soon as the court process, the wills court process is over, his twin boys get the money equally right away.
And I have 2 lovely twin boys that are 26 years old, David and Daniel. And I will tell you right now, Daniel probably has every dollar he's ever saved in his life. In fact, when David was I think around 13, he used to go to his brother and say, hey, can I borrow some money? Because my birthday's coming up and I need some money to go do something. And so if you give me the money now, I'll go ahead and give you the money back when I get my birthday money. So I love David to death. I love Daniel to death, but I don't want that money going to him outright at 26.
Right. So sometimes this is not such a good thing. This is why I mentioned earlier, if you have, the property in other states, there's a different reason to have a trust. But if you have beneficiaries that are minors, you probably don't want all that money going into an account right away for somebody to spend for them. If you have a special needs person, I mentioned them down here, pets, children, and special needs individuals, or in Glenn's case, somebody who is a spendthrift, somebody who spends all their money right away, you might not want the money paid out as soon as the probate and the wills court process is over. So a trust gives you the flexibility of being paid out over time. So something I'm going to mention at the outset of this board, sort of, is that trusts I often hear I hear people say, well, I'm not rich enough to have a trust. That is not, that's not in reality, guys. Like, a trust is just a different way of passing property to the next generation. It is not something reserved for the wealthy. The reason people think this is because money is typically paid out over the course of time. That's one of the benefits of having a trust. It doesn't have to be, though. You can use a trust just to avoid the court process. That's another reason that people create a trust. But a lot of times people think, well, trust fund baby, therefore they're rich. That's not necessarily the case, guys, because think about it like this. you have two 26-year-olds,
26-year-old twins,
26-year-old
yes.
boys, and you have, let's say, Glenn's estate was just diminished down to 200,000 when he died. Do you want your kids to have $100,000 at 26 at their disposal, or do you want that to be given to them over the course of time? Maybe they'll make a little bit better financial and economic decisions with that money. But a lot of times when we liquidate our houses, our IRAs, our 401ks, and all of our assets, it's significantly more than $100,000 per beneficiary. The thought process is, well, do I want to provide for my beneficiaries over the course of a set of years, or maybe they're a little bit older? Do I want them to have money into their retirement if they haven't planned for themselves? There's a lot of reasons why people might want to pay people over the course of time, as opposed to having it paid as soon as you die. One of the reasons I write children over here is because the trust allows you to pay over time. You're allowed to tell the guardians of your children through your trust document how you want money spent on their behalf. So this is very important for people with minor children, I think, is if you die and somebody else is handling raising of your child, do you want them to cover things like sports? Do you want them to pay money for extracurricular activities? Do you want them to go to private school? Do you want them to be in Catholic school? Do you want the money to be preserved for their education for the future? Or do you want to provide whoever's caring for them, do you want them to be on an allowance? They get a certain amount of money per month out of the trust, and then the rest is preserved for the kid's future. Those are the types of decisions that you can make and the thoughts that can go into making a trust for your children.
I think we have a question. Is that right?
We have a question. What if I have a house paid off or mostly paid off, but also I owe credit cards in my car? Will the trust have to pay the credit cards with the house money before it goes to my kids? That's a great question.
Really
So
is a good
in
question.
Florida, your house that you consider your primary residence is your homestead property. So if you claim homestead, this is not really applicable for a lot of our snowbirds that don't claim homestead in Florida. But if you have a home here considered your primary residence and you claim homestead, your creditors cannot touch the value of that house. So let's say your house is worth $1 million and you owe $2 million. That does not matter. Your children, if you have children, lineal descendants, they're able to inherit that house without having any money paid towards those creditors. Now, in the law, it provides that certain debts are paid off in the event of your death. But a house is unlike any other asset that we have in Florida. It is absolutely protected from all creditors except the mortgage company itself, HOAs, and certain tax levies that can go on your property.
So to answer the question a little more directly, if you have credit card debt in your name only, and there's money left over from the sale of this house, what would happen?
It goes directly to the kids. So it would not be paid to your credit card companies. In fact, credit card companies are, I believe, a class 7 creditor. There are different classes of creditors in Florida that get paid. That's very low on the list.
Now, it's two things I think is interesting. Understand that doesn't mean the credit card company won't try to get money. Okay,
That's right.
I have this happen all the time. I thought you said
That's a great point.
Right, I thought you said I didn't have to pay my dad's debts who just passed away, and I go, okay, I said the law said you didn't have to do that, but that doesn't mean that XYZ credit card company can't call your house or send you a letter saying, hey, your dad died, you owe money. And we see it
And
happen
they
all
will
the time.
try to collect their money, but when somebody dies, you should not pay any bills
Correct.
without speaking with a lawyer.
And then
because there's the executor or personal representative of the will is entitled to money before any bills get paid. Your attorney, because lawyers wrote themselves in the law that your probate attorney gets paid before those debts get paid. And there's other classes of creditors or taxes get paid. Your funeral bill. So let's say your funeral bill is $5,000 and you owe $5,000. A funeral bill can get paid before any money goes to those credit card companies. Things like that people really need to know. So if somebody does die, it's important to get legal counsel, and that's paid for out of the estate funds, not your personal money.
And one thing I'm looking time-wise, we're about 15 minutes left. And so one thing I do want to say about trust and wills, and again, this is just my experience all these years. One thing I want you to understand is the will process, right, because it goes to wills court, is a totally public process. So I can go down and I can pull out anybody's will who's been presented to the court. I can see everything written in there. I can see who gets the money. I can see how much money there was. It's totally public.
100% public proceeding. So on this side, I wrote private
Correct.
because your trust proceeding and how you administer the money to the next generation is private between you and your beneficiary. So Glenn couldn't go down to the court and say, hey, I want to see Debbie's trust. That's all private.
Now, there are people that go and get wills and find out that people have money and they start making phone calls. So one of the things that I think is really important to understand, if you're a very private person, which I am, the ability to not have this whole process be private and no one know about anything that's going on is an extremely important thing for myself. And I think I've had a lot of clients and a lot of people who've spoke to me over the years that is a major point that's, I think, sometimes missed in why you would do a trust. Like Debbie said, everybody thinks it's only for wealthy people. No, it's for, frankly, it's for everybody. If it makes sense that you're trying to control things over time.
And especially if you have property in other states, because you're going to have 2 wills court processes, which drains out a lot of money out of the estates, thousands of dollars. And if you have pets you want to provide for, like myself, or having my dog, or children that you want to tell the people who are going to be guardian of your children what you want spent on their behalf, it's very important. And also, I haven't really mentioned, but people that have special needs beneficiaries, that's anybody who receives like Social Security disability check or is going to have an ongoing special need. The trust gives you the flexibility of basically making sure that any inheritance they do get will not kick them off of any public benefit that they receive. So that's very important.
And I think the one that I want to get on is
creditor
protection. I'll let Debbie go first on creditors, and then I'll talk about predators, because I think those two things are very important. So
in a trust, a lot of times people say, well, doesn't a trust fund keep my money protected from my creditors? The answer is no, not from your creditors, because you are in charge of all your trust money until you die or become disabled. So it's considered yours. But you can protect it from your children's creditors. So let's say I die and I leave my money to my nieces and nephews, and one of my nieces just filed for bankruptcy right before I died. She had a legal situation or whatever, and she just, she filed bankrupt. I can write in my trust that if that's her situation when she inherits, her money is locked into that trust until the legal situation evaporates. So something Glenn often talks about is if there's a bad spouse, which we know we have.
Yes,
how many of you hate your daughters-in-law and sons-in-law? I know you're out there. So a lot of times people say, well, I don't want my son-in-law, I don't want my daughter-in-law ever getting any of my money. You can absolutely write that in there and protect the money in trust for your child to make sure that their spouse never gets a dime of that money. You can also make sure that if your children get in a car accident right before you die, and there's a possibility they'll lose their inheritance, that money is locked up, tied in trust, it's still sitting there for them, it's growing for their benefit, but it's not paid out until their legal situation is gone, and there's not a likelihood that they're going to lose that money to creditors.
And I think my great example that I've seen over the years many, many times is that, let's use my twins for an example. One of them gets married, and so they don't have to be the bad person. They go, my dad, he is such a jerk. The money he put in trust, I can't get it. I got to go to Kevin and I got to ask him for money. But you know what? At 26, I probably would think that Kevin, one of my best friends in the whole world, who's a CPA, if he comes and says, David would probably say, hey, I need a new car and I've been looking at this Ferrari. And he'd go, well, how about like a used Lexus? And I think that might be a little better of a choice. But my point is to not have it be a situation where it causes issues between young married couples. It's just, hey, dad and mom together, they're really jerks.
They locked it in the trust.
I don't have access to my money, and it's not something you have to deal with that. They don't have to deal with the conversation. They just blame it on the parents. And
that's one of the special things about having a trust is that if the money is paid over the course of time and it's tied in trust, your kids don't have to have that conversation. Your kids can say, it's tied in trust, I don't have access, but you can give the successor trustee, the person in charge of the money, discretion to pay out whenever you think is necessary. For example, sometimes we write in here that the successor trustee has the discretion to pay money if my kid extra money, if my kid gets married, has a baby, starts a new business, goes back to school, then whatever we say that they're getting paid, they can get paid extra money in those instances, but we leave that discretion to a third party. One of the things I just want to briefly talk about, because we're wrapping up here, is that 3 ways that you can essentially trump, pardon the expression, your estate plan and make sure that these documents don't have any legal effect is if you have joint accounts, which deeds and beneficiary designations. So we're going to go through each of them. What this means is that if I have a joint account with Glenn, and my will or my trust says, I want all of my assets left 1/3, 1/3, 1/3 to my niece and nephew. No matter what my will or trust says, if I own an account with Glenn, Glenn gets that account. So sometimes this comes up, it actually comes up very often in my practice. People say, well, I don't have to worry. I have a child, I have a kid with an account with one of my children, but my will says it's all divided, so it's all fine. No, if you have a joint account, it goes to that joint owner. So you have to make sure that these type of financial decisions are coordinated with your plan. Like if you want your one child to have that account, great, good job. But if that's not your intention, you have to be careful about that. Second thing is deeds. If I own a house with somebody else with right of survivorship, that's the key part here. With right of survivorship, that house or parcel of land will go to the survivor, will not go according to my will or my trust. So that's a way that you can defeat your estate plan, or you can, go with your estate plan. Some people say, well, I want my daughter to have my house because she's the one who paid for it, and then everything else is split. Well, that's great. And we have the daughter on the deed, and then everything is still even in the will or trust. And finally, beneficiary designations. So if you they have a financial advisor like Glenn who has, your IRA or 401k, if you beneficiary designate on those accounts to specific people, no matter what your will or trust says, it will go to the people on your beneficiary form.
And
so
do
it's
you want
very
to know how many
important
times we have the ex-spouse as the beneficiary because they forgot to update it on their 401k or an older 401k from a previous employer that they forgot about?
So in our world, in the lawyer world, if you leave your ex-spouse on your will or trust and you forget to redo it, they are considered dead for purposes of your will or trust, but they are not dead if they're on your beneficiary designation. So what happens is if you don't work your estate plan with both your financial team and your legal team, there's things that can fall through the cracks like that, where your ex-spouse might get all of your IRA on accident because you forgot to update your beneficiary designation. So it's very important. And the final thing I'll cover on here, which is what was on the back, is that anything that you want your trust to govern, you have to put inside that circle that I drew on the back. It covers property that's inside your trust circle. So I'm just going to flip this over real quick so I can end on this note. And it's important, guys, that if you do have a trust document in place, that you go through the funding process. This is not hyper legal. It's mainly financial that you have to worry about. But you can put your houses into the trust. You can put your IRAs beneficiary designated to your trust, your insurance policies beneficiary designated to your trust, and everything will go in accordance with your instructions. And that's the very important and critical part of doing your trust document. And that's not something that your attorney can do by his or herself.
And so let me kind of finish up here on something that I think I have been trying to get people to understand on this estate planning process. There's a planning aspect to it, and then there's a document aspect to it. And what I find, and this is what the Estate Planning Council and all those professionals who are basically donating their time to help, is to think through the planning process. So let's look at how this really works. Somebody comes into Debbie's office and they sit down and they go, hey, I want an estate plan. I want to do this, I want to do that. They probably haven't done much thinking about a lot of stuff. So she starts asking questions. Who do you want as a beneficiary? How do you want it all to go out? Who do you want to have as your trustee? And then understand certain assets transfer very well to the next generation and some don't. So what I see missing a lot is the planning aspect. So what this looks like is talk to somebody, whether you have a planner or you need someone to walk you through thinking about all these things first. Then you have your plan. Think it like a blueprint of a house. If anybody's out there ever built a house, you start off with a blueprint. Now, you change the blueprint. I know I've built several houses. You move a window, you change things. You have a chance to live with it before it gets constructed. The problem is that we don't do that step, and we just come to Debbie to build a house. And then after it's built, we go, darn, I wish I would have done this. Darn, I wish I would have done it. I never thought about this. The other thing I want you to know is if you do need any help in the planning aspect of it, that's where we can help. I donate my time to the Gulf Coast Estate Planning Council to help people like this. We can walk you through the process. We can give you some really good tools to use that. The Family Love Letter is a great way. And so I want you to see there's planning, and then there is the legal documents. And maybe the last thing to talk about is not too many people have heard about a law change. And if anybody's heard about the stretch IRA, that said that if I passed away, I could stretch my IRAs over my children's lifetime. That's a great strategy. We've been using it for years.
Decades.
December 23rd, that law changed, and basically my children only have 10 years to be able to distribute that money back. So here's an example of a process and a way that we used in planning for years that changed as of December 23rd, and it's a huge change. And so these are examples of things of why we have to always look at the planning aspect of estate planning. So any other last notes or anything like that?
Just
Okay.
thanks, guys, for showing up. We look forward to seeing you at another seminar.
Thank
Take
you.
care. Bye.
Bye.
That's it.
Wow.